Open the hearing on AB, was it 267, Mr. Hambrick's bill? There he is. Mr. Speaker, welcome. Thanks for your patience. Come on up.
Good afternoon, Mr. Chairman, members of the committee. I truly appreciate the opportunity to appear for you. For the record, my name is John Hambrick, and I'm privileged to represent Assembly District 2. The bill we have before you today, AB 267, is somewhat unique. This committee is used to me coming in and talking about bills relating to human trafficking. This bill relates to a bill relating to the care of, for lack of a better term, and I don't want to be too melodramatic, but human souls. We deal every day with young minors who are charged with a crime, very serious crimes, and through no fault of their own, after they are charged, and they may be waiting for a trial date, which could go perhaps a year or 2 years, and would go beyond when they were minors and into adulthood, which causes a particular problem. I have on my left side James Dolt, who is very familiar to this committee on several other issues, and I'm the presenter, and he is the author of the bill. And we have a witness on my right. But, Senator, I realize that you want to be very careful in how many witnesses we had. We had a lot in the other house, and you'd prefer to keep this a little quicker, a little ease your testimony, because I know you've had a long day and you have a long evening yet tonight. So with the chair's indulgence, I will turn over the actual presentation of the bill to Mr. Dolt, if it pleases the chair.
Yes, that'd be great, Mr. Hambrick. Thank you very much. Welcome.
Thank you so much, Mr. Chairman and members of the committee. Thank you for the opportunity to testify before the Senate Judiciary Committee. My name is James Dold. For the record, I represent the Campaign for the Fair Sentencing of Youth, which is a coalition of individuals who come together to work on more fair and age-appropriate sentencing standards for our youth when they are convicted of serious crimes. Let me just note at the outset and thank the Assembly Speaker John Hambrick for his leadership in introducing this bill, as well as John Jones at the District Attorneys Association and Connie Bisbee, who we work with on this language in the bill. I thought during this presentation I might start off by going through the components of the legislation and then shifting and discussing why this bill is so important and so appropriate for the state of Nevada and really all over the country. Without further ado, the first section of the bill, which starts on page 2, discusses the requirements that judges must consider the differences between juveniles and adults when juveniles are being sentenced in adult court, including the diminished culpability of juveniles relative to adults. And that language comes directly from a Supreme Court case, Miller v. Alabama, which I'll talk about a little bit later on. Section 2 prohibits the imposition of a life without parole sentence on a person who was under the age of 18 when they committed an offense. Section 3 deals with the parole eligibility of those individuals and would set parole eligibility at 15 years for individuals convicted for crimes committed as minors, at 15 years for non-homicide offenses, and 20 years for homicide offenses where there was only one victim. And then Section 5 of the bill makes these provisions retroactive so that it would apply to individuals that are currently serving life without parole sentences if they meet the specifications of this legislation. I think it's important to highlight that one of the things that this bill does not do is it's not a free get-out-of-jail-free card. It's really important to note that judges retain the ability to impose life sentences for both homicide as well as non-homicide offenses. This is just dealing on the back end to say after a certain period of time, the parole board has the ability to go back and see if these people have been rehabilitated, if they've changed, if they've grown over time, in line with the meaning and the spirit of several recent U.S. Supreme Court cases that have come down. And so we tried really hard working with the DA's Association as well as with the parole board to make sure we have an appropriate balance of striking, of making sure that we're protecting public safety, and also recognizing the fact that we're dealing with juveniles who are convicted of some of these serious offenses, and that no child should be sentenced to die in prison for a crime that they committed as a minor. So a little bit of background about this legislation and how we got to where we are today in discussing it. Back in the 1980s, there was a juvenile crime wave that happened, and a bunch of criminologists from across the country had theorized that this juvenile crime wave was going to continue to spike and continue to go up, which resulted in this theory called the super predator theory, which theorized that there was a new generation of juvenile delinquents that were more violent, more remorseless than ever before. They were characterized as being jobless, godless, and fatherless. And this led to a whole host of states passing laws that made it easier to transfer kids into the adult criminal justice system, opening them up to adult penalties, including extreme sentences like the death penalty and like life without parole sentences for juveniles. So fast forward to the year 2005, the U.S. Supreme Court begins to weigh in on these sentences as they're applied to minors. And in 2005, the court, in a case called Roper v. Simmons, struck down the death penalty for juveniles. The court, in an opinion authored by Justice Kennedy, highlights a couple of important components that I'll go through briefly. First, Justice Kennedy notes the juvenile brain and behavioral development science that show that there are fundamental differences between juvenile and adult brains. This is things that every parent and grandparent knows, but really science for the first time was being able to show us. And specifically, the part of the brain that's responsible for decision making, the prefrontal cortex, isn't fully developed in juveniles the same way as it is in adults. And as a result, children actually rely on the amygdala to think with their brain, which makes them more impetuous, more susceptible to peer pressure, and making rash decisions, as it were. So that was the first major component of this decision that Justice Kennedy highlights. The second is the international consensus against imposing the death penalty on juveniles. And since 1990, Justice Kennedy had noted that there are only a handful of nations that had actually sentenced children to death, including Iraq, Somalia, Saudi Arabia, and the United States in that category. And so it wasn't exactly the best company to be in. And the third thing Justice Kennedy noted was that there was this great difficulty distinguishing between the irredeemable youth who might not be rehabilitated over time and the overwhelming majority of kids who can be rehabilitated over time. And he cites, some of the crime statistics that we know of today, the fact that there's about a 50% decline in criminal activity by the time a youth reaches the age of 22. By the time they reach the age of 28, that percentage goes up to about 85%. We call this aging out of criminal behavior. And this applies across the board to kids who are convicted of committing serious offenses. So that was the Roper Court. 5 years later, in a case called Granby, Florida, the court took up the issue of life without parole sentences for non-homicide offenses. And here the court, again, relying on the already established reasoning from the Roper decision, strikes down life without parole sentences for non-homicide offenses. What was interesting in this decision is that Justice Kennedy, again, the chief author, highlights that life without parole sentences are very much akin to the death penalty for children because, in fact, you're sending a child to a cell where they're going to die and they'll never have an opportunity to leave prison no matter how much they change or no matter how much they're rehabilitated over time. And so this was a very important part of this dynamic for Justice Kennedy in writing this opinion. And again, sort of looking at the rehabilitation models and the fact that so many kids change over time and the great difficulty distinguishing between juvenile offenders who commit serious offenses as a part of transient youth and those who can't necessarily be rehabilitated. Then finally, 2 years later, in Miller v. Alabama, the court takes on the issue of mandatory life without parole sentences. There, the court strikes down mandatory life without parole sentences for juveniles convicted of homicide offenses, invalidating 28 statutes across the country, and requiring that judges, anytime a child faces a potential life sentence, has to consider certain mitigating factors of youth, including the provision that I mentioned in Section 1, the diminished culpability of juveniles relative to adults, and those types of distinctions. Since the Miller decision, several states have ruled that that decision should be applied retroactively. Of the 14 state Supreme Courts that have taken the issue up, 10 have held that it should be applied retroactively, including Texas, Mississippi, South Carolina, Florida, New Hampshire, Nebraska, Wyoming, and Massachusetts. And then states with discretionary life without parole sentences, including Ohio and South Carolina as well. In response to these Supreme Court cases in the emerging juvenile brain and behavioral development science, several states have been proactive in removing the possibility of sentencing a child to life without parole. I'll mention a couple here, including Texas, Wyoming, Montana, West Virginia, Kansas, Kentucky, Massachusetts, Hawaii, Vermont, and Delaware, just to name a few of those states. And I mention those states because they show a very wide breadth of both political and geographic diversity in the states that have enacted these reforms. It's been on a bipartisan basis, again, sort of looking at this through the lens of a human rights issue. The United States is, in fact, the only country in the world that is known to still use the sentence of life without parole on children in violation of a couple of international treaties. And so as a result of all of that, the American Bar Association has also been very proactive. In February of this year, they passed Resolution 107C, calling on all states and the federal government to eliminate life without parole as a sentencing option for children. I'm saying that children should have a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. And we've seen across the board great bipartisan support that really runs the gamut. We've worked closely with former Speaker of the House, Newt Gingrich, former President Jimmy Carter, and so we really see bipartisan consensus on this issue across this country. And so with that, I'll go ahead and wrap up my presentation. I'll be happy to answer any questions on the law or any specifics about the legislation.
Okay, thank you very much, Mr. Dole. We appreciate you being here. That was excellent. Thank you. I don't see any questions at this time. Mr. Hambrick, anything further?
No, Mr. Chairman, we'll step back depending on any other witnesses, so we will stand by should the questions develop during the course of the hearing. But we'll be here for the entire hearing until you close it.
You have no further witnesses then?
Oh, Xavier, please.
Thank you.
He looks great sitting next to you, but I figured he'd want to say something too.
Somebody's got to look better than I do.
Yeah.
Yes. Well,
Welcome,
first of all,
sir.
thank you for having me. For me,
Just make sure you state your full name for the record.
yes, my name is Xavier McElrathbey. I'm a youth justice advocate with the Campaign for Fair Sentencing of Youth. I'm also the co-founder of ICANN, which is the Incarcerated Children's Advocacy Network. And my work involves coordinate a national network of formerly incarcerated individuals who were all convicted of murder as children. And the reason why this work is important to me, as well as my presence here, is because myself, at the age of 13 years old, I was arrested, charged, and I was later convicted to serve a 25-year sentence in prison for my involvement in a first-degree murder. At the time, I must have weighed probably 112 pounds. I was probably 5'2", 5'3". I was very very much a child, but unfortunately, the only thing that the court had to identify who I was and express something about my history was, unfortunately, rap sheet, which was 19 arrests and 7 convictions. At the time, I was viewed by the court, unfortunately, as someone who was incorrigible, someone who was beyond repair, who was irredeemable, more specifically in the juvenile court. My probation officer fought very hard to have me transferred into the adult court system. But something very strange happened when I entered into the adult court system. I met a public defender, Ms. Herschella Conyers, and in our initial interaction, I noticed something quite different, and that is that she was looking into who I really was inside. She asked me questions that were not typical of my previous experiences with public defenders. She recognized that very much I was still a child. She came to understand that I came from a background of some very extreme circumstances of abuse and neglect, that I had grown up in foster care and group homes, that I had been a victim of child abuse very early on, that I was also a victim of a gunshot at the age of 11 years old, that I had seen much violence in my community. And what was unfortunate was that for the most part, this was unexpressed up until that point. A lot of the people that I had met prior to that never really looked into the depths of my life, what I experienced growing up, but more so looked at my behavior and was very punitive. But she convinced the court that I was a child. And I think that's what we're trying to do here. We're trying to convince this committee that these are children. And when she convinced the judge that I was a child, instead of giving me 60 years, which was what the state had recommended, he gave me a 25-year sentence. But under the old law, that meant that I would be free in my mid-20s. And little did they know, perhaps they in some way did believe that I had a potential for change. And during my course of incarceration, I did grow up. I did mature. I did become more remorseful and more thoughtful of the future in the hope to someday live a normal life. And today I have to say I live my life as an eternal apology to the victim and his family, to those in my community who I had harmed, to those who, for the most part, perhaps never saw it coming, that I would become a better person. But because of the grace of God and a lot of support from people in my life and opportunities that was given to me, much like we hoped that these individuals would have, I was able to come out and demonstrate that I was better than my worst act. And so I hope that the committee will give these individuals the same opportunity that I had to someday come out and live a normal life, to prove that they are better than their worst act. While I was incarcerated, I ended up getting an Associate of Arts, an Associate's in General Education, a Bachelor's in Social Science. I had a 4.0 GPA. Franklin Honor Society, was inducted for outstanding scholarship. Came out in the past 13 years, I've worked in gang intervention, violence prevention. My most recent job prior to this position here, I was a clinical research interviewer with Northwestern University that looked at the mental health needs and outcomes of formerly incarcerated youth. And I just believe in my heart, especially because of the individuals that I know through our national network, but that these individuals who are in there now, that they too have the capacity for change, that we're not irredeemable, that we're not beyond repair. And I just hope that you give them a chance that I had. Thank you.
Well, thank you. That was excellent. We really appreciate you being here today. So how old are you now?
I am 39 years old.
You still look
Yeah.
like you might be a juvenile.
Thank
Maybe
you.
I'm just getting
Thank
old.
you.
Everybody looks young. Senator Keenan looks like he could be 18. I don't know. I mean, that happens to you.
Thank
yeah.
you.
So, and you live where now?
I live on Logan Square in Chicago.
Okay.
I grew up on the south side of Chicago.
Okay. All right.
Yes.
I'm originally from the south side of Milwaukee, and if you know
Okay,
anything about the
okay.
south side of Milwaukee, it's just like the south side of Chicago.
Yes, yes,
Wow.
yes.
So, at what age were you incarcerated then for the last time?
I went in at 13 years old. I came out when I was 27 years old. So,
Okay.
And this was an age when, strangely enough, developmentally, this is a time when we know that the brain is fully formed,
Right.
that the prefrontal cortex is fully there. And I think that, when we look at sentencing schemes that are age appropriate and trauma informed, I think that what we try to emphasize is the importance of a meaningful opportunity for release and giving that hope and having the light at the end of the tunnel. And I think that's what we really want to provide. We're not saying open the door, let them all out, but give them a hope, something to aspire towards. And I guarantee you that the majority of them, if not all, will definitely aspire towards something better. And that is what we hope.
Well, thank you very much. And I didn't mean to be distracted
Yeah.
when you were testifying. I was actually trying to. This strikes a chord with me because I have prosecuted a juvenile in the federal system as an adult, and I was trying to remember exactly what sentence he got. He pled guilty to conspiracy to commit murder and ended up getting 20 years from the judge, which in the federal system, means 20 years.
Yeah.
And it's an interesting part of our jurisprudence, as you know, this juvenile to adult law, a series of laws that we have. I really appreciate you being here. Thank you.
Thank you
Any
so
questions?
much. Thank all of you. Thank you.
Okay, thank you very much, Mr. Speaker. We appreciate you being here with this bill, and thank you, gentlemen, both. Who else would like to testify in support of AB 267?
Thank you, Mr. Chairman.
Oh, yes, in Las Vegas. I
Vice-
didn't even see you there. Thank you very much. Please, go ahead.
Thank you. Thank you, Mr. Chairman. My name is Christina Wildeveld. I'm here as a private criminal defense attorney who has spent the majority of my 20-year career representing numerous defendants who are sentenced to life without the possibility of parole, as well as those who were given extraordinary sentences for crimes they committed before their 18th birthday. I'm grateful for Chairman Hambrick for introducing this bill. Here today, while Xavier is from Illinois and there are transfer hearings in Illinois, under the laws of the state of Nevada, when a juvenile is charged with murder, no matter what their age, they're automatically in the adult system. They do not go before a juvenile court, and there is no transfer hearing. In murder cases, the direct file is automatic and non-appealable. Even if they're children of addicts, abused, victimized, any of those issues, the charging document alone magically turns a 12-year-old into a 19-year-old adult, and they're treated as an adult, clearly when they aren't. While it may be instinctive on some levels to view this world in terms of doing the crime and doing the time, passing this bill does not forgive these kids' crimes, but acknowledges what science says we can't ignore and aligns the criminal justice system with what science says is true. They still live with their crimes forever, and their victims will never be forgotten. I know a lot of these kids. I know a lot of their vulnerabilities, their openness to rehabilitation, and their deep remorse. In fact, we had Mario Taylor and Marcus Dixon here present today, and they are Nevada youth and are examples of Nevada juveniles who have successfully transformed their lives once given a chance for release from prison. Both of the young men were serving lengthy prison sentences and had the opportunity for release for crimes they committed when they were 14 and 15 years old. They had the opportunity to testify before the assembly along with Tracy Rutherford, another female in Nevada. And I encourage the body to review their testimony as well. For the most part, these persons are no different from the youth that are currently serving lengthy sentences, but for a careful negotiation or a prosecutor who is willing to not go after a death sentence. I thank you for your consideration of this bill and am present to answer any questions you may have.
Okay, thank you very much. Let's go. We'll stick with Las Vegas. Yes, ma'am. Please go ahead.
I appreciate the opportunity to speak. I will be very brief. I'm going to completely agree with everything that Christina just said. My name is Megan Hoffman.
Ms. Hoffman,
and
could
I
you
am an
move
attorney.
There you go, a little closer.
Yes.
Thank you very much.
Yes. My name is Megan Hoffman. I am speaking today as a private citizen, but I'm also speaking based on experience that I have as an assistant federal public defender. I am the chief of the non-capital habeas unit with the Office of the Federal Public Defender here in Las Vegas. And through that representation, I've had the opportunity and am currently representing several defendants who have been sentenced to life without parole sentences in Nevada as juveniles. And I am currently litigating and working on their cases. And so based on that, based on Christina's statements and all of the testimony that is here today, I fully support this bill and believe that it would serve the citizens of Nevada and in particular the juvenile defendants that we currently have incarcerated in Nevada. I'm also available to answer any questions based on Nevada or Ninth Circuit law if that's something that the committee has questions on.
Ms. Hoffman, I just had a question. I think if I heard you correctly, you say you're representing several persons who were convicted as adults having committed crimes as children in the federal system?
So, yes, Your Honor, I am representing individuals convicted in Nevada state courts who are now appealing those state convictions into federal habeas proceedings.
Okay.
And so I represent individuals that have been convicted by the Nevada state courts.
Right.
Our office has represented, obviously, we're a federal public defender's office, and so we do have cases, possibly the one that you referenced earlier, of juveniles, but I represent folks that have been convicted in state court.
Yeah, well, the one I referenced earlier was a guilty plea, so you probably don't, of course. But I just couldn't remember a federal case with a life without sentence, so you stumped me there for a second, but thanks for the clarification. Okay, thank you very much. Back to Carson City. Ms. Spinizzola, please.
Thank you. Chairman Brower, Vanessa Spinizzola with the ACLU of Nevada. This is a great second chances bill. We're in support. I just wanted to note for the record, Dr. Walsh was here earlier. She had to leave. She's with UNR. She's a tenured professor there in human and family development. She put a 4-page letter on the record that talks about the prefrontal cortex and all that type of information. I just want to note that for the record.
Thank you very much. Seeing no questions, Ms. Comas?
Thank you, Chairman Brower. Reagan Comas representing M&R Strategic Services, and I just want to voice our support. Also, as noted by Mr. Dole, we have been working with Connie Bisbee at the Parole Board, and they did have concerns initially, but they have been addressed and they are neutral on the bill.
Okay, thank you very much. Mr. Jones, please.
Thank you, Chairman Brower, members of the committee. My name is John Jones. I'm here on behalf of the Nevada District Attorneys Association, and we are here in support of AB 267. I do want to thank the sponsor, Speaker Hambrick, Mr. Dold, and others who have worked with us on our concerns regarding this bill. We are here in support. I do want to make one clarification for the record, though. There was a statement by Ms. Wildeveld that juveniles are now at any age subject to adult prosecution for murder. And while that was true in the past, in the 2013 session, this body passed AB 202, which now makes it basically a direct file or automatic adult offense for any child over the age of 16. So any child between the ages of 13 and 15 are subject to what's called a certification proceeding. And that is where a juvenile court judge determines, based on the nature and seriousness of the offense, the child's prior record, and any subjective factors, whether or not that child should remain in the juvenile system for that crime or be sent into the adult system.
Thank you for clarifying that, Mr. Jones. I remember that bill about as well as you do, I'm sure, for better or worse, but a good result, I think. Okay, thank you. Mr. Sullivan?
Thank you, Chairman Brower. Sean on behalf of the Washington County Public Defender's Office. We just wanted to register a quick Me Too to AB 267 and show our support. Thank you.
Thank you. Mr. Yeager?
Steve Yeager, Clark County Public Defender's Office. We are in support of Assembly Bill 267.
Okay, thank you very much, gentlemen. Seeing no questions, is there anyone else here who would like to testify in support of AB 267? Seeing no one moving, any neutral testimony on the bill? Yes, sir, come on up. You want to testify neutral on the bill, is that right?
Neutral.
Okay.
I don't know if it's a neutral, it's just a question.
Great, why don't you have a seat, make sure you identify yourself, turn the mic on, and go ahead. I don't think so. Is the light on the button? Try it and see if it lights up.
Okay.
There you go.
Okay, my name's Jim Zeitler, just visiting for a couple days. I think it's a great bill. My question is, if the bill is passed, how is anybody affected who was convicted of a serious crime 10 years ago as a juvenile and sentenced to life in prison? In other words, does it affect any of the punishment that it's already been passed to those before the bill was passed?
No, the bill appears in Section 5 to relate to offenses, only offenses committed on or after October 1st, 2015, or for convictions on or after October 1st, 2015, depending on the specific section of the bill.
Okay, thank you.
Thank you. Mr. Dolt, was I wrong about that?
Yes,
Please,
sir.
please correct me if I was.
So the first provision, so all the provisions apply prospectively except Section 3. Section 3 will apply retroactively, so it will impact the individuals
you're
that
right.
were sentenced to life without parole.
Committed before,
previously.
on, or after.
That's correct.
Thank
Yes,
you
sir.
for that clarification.
Absolutely.
Just checking to see if you were paying attention. Some people testify, and then they stop listening to everybody else, but you're obviously not one of them. Thank you. Great. Anyone else who would like to testify neutral on the bill? Anybody here in opposition to AB 267 who would like to testify? Okay. Mr. Speaker, would you like to make any closing remarks before we shut it down? Well, again, thank you very much. We appreciate all of you being here, gentlemen. Thank you. Excellent testimony. Seeing nothing further from the committee, we will close the hearing on AB 267 and open the hearing on AB 214.